evening, everyone, and welcome to the front house. So, in Barbados, we know the front house is where real discussions happen, real serious discussions happen in Barbados between families and friends. So, welcome to the front house. I am Stacia Brown, your host for this evening, and this evening we are taking a look at the Child Protection Bill in Barbados. That was introduced last week in the House of Assembly by our Minister of People Empowerment and Elder Affairs, the Honorable Kirk Humphrey. So today we have two amazing, knowledgeable experts with us, two young ladies. Felicia Dujon, who is a mother. She is a lecturer in philosophy at the University of the West Indies, and she's a farmer, she told me yesterday, which is a really interesting fact. And we also have with us Tyra Trotman. Tyra is an attorney. She's young, she's bright, and she has a lot of fire, I like to say. So welcome to you both, and let's get underway in our front house. So thank you for everybody who's joining us here online, whether you be on Facebook, YouTube, Instagram, wherever you are in the world, you're joining us here in our front house. So as we walk through this, Felicia, tell me why you think we need a new child protection bill in Barbados.
I believe if we've had a bill, good afternoon, everyone, and welcome to the front house. It's quite cozy here, I must say. I believe that if you have any society has a bill that was established in 1904, it would be prudent that you seek to see or implement a law that reflects the society that we live in now. It has to include various aspects that is reflective of the society want to emulate, and of course a society that is conducive for everyone, because we do want a society that is safe, in particular for our children. And very rightly to what the minister said, that if we had a law or bill that was established during slavery, we can almost imagine what was happening at the time, which placed African families at a disadvantage, African children of African descent at a disadvantage. However, if we're seeing several centuries later where we have a bill, it also has to reflect the society that we live in. And so it's very important that when we speak about children's rights, that we look at the holistic way of focusing on children and what we as a society mean by greater protection for children. And so we have to take every resources, our time, our efforts, and do it in a way that is collaborative, as opposed to this is my government and this is what we want to do. It has to be holistic, because when you create bills, you create laws, it reflects the entire society. It's not dependent on what political party you support, what religious perspective that you take, but every citizen has to be covered in that bill. And so one of the reasons that I believe that we as a society need to reflect a lot deeper with this bill is the fact that when legislators design bills, it is not for tomorrow or for next week or next month or the following year, but sometimes those bills last centuries, as we've seen. And so it must reflect the society, as I said before, that we want in the future. So it's important that when we design those bills, that we do not pass bills that are inadequate, incomplete, and have quite a lot of ambiguities. The language has to be clear, that it is not misinterpreted or interpreted in different forms or format by various persons. And so these are the positions that I have taken, that we as a society, we as a government and a responsible government need to seek ways that we can ensure that every citizen who sits down and look at this bill can say, yes, I understand what this means. I don't have to interpret it differently than my colleague or my neighbor next door, that we all have a clear understanding of what is happening. And so at this point, we ought to do what is right and what is ethical to ensure that this bill, it is not ambiguous and it's not arbitrary in any way for the protection of our children.
Okay, thanks so much, Felicia. Now, so Felicia brings the perspective of the child and parent advocate here, and that's a much needed voice we need to have in articulating any legislation or looking at any legislation. And Tyra is our attorney at law. So Tyra, from your perspective, what do you think on why do we need this specific bill coming up now?
Well, first of all, thank you for having me. It's a pleasure and a great opportunity to be able to speak out on this. From a legal perspective, legislation is usually created to remedy a mischief. The mischief here that is trying to be remedied is the fact that there is something called child abuse. As Minister Humphrey said, there are over 600 and something cases of child abuse being reported annually. So that puts us at about 2 reported cases per day. And these are just the reported cases. There are many unreported cases because of the nature of the allegation or the accusation. Sometimes it's a family member. So because of the shame, and perhaps sometimes when children complain, they're not believed, all these different type of things come into play. So there was a need for it to correct that mischief. The mere fact that there is child abuse and we do need to protect our children. So we're not saying we don't want the bill. Of course not. We're not saying we don't want our children to be protected. Of course not. We're not saying don't remedy the mischief, which is child abuse. What we are saying is if you're going to do it correctly. Do it thoroughly. Do it with enough information and research so that years from now we don't have to revisit this piece of legislation because it created further mischief, further abuse, further neglect. But rather, we're in a position years from now where we can say, yes, this legislation, we've seen the numbers, we've seen them go down because people understand how serious this is. People understand that when they do these actions, there will be sanctions. Children feel as though they now have rights and they can be heard and they're protected. And so we create a better society for everyone. That is the position we want to be in 5-10 years from now, not looking at the legislation and saying, oh dear, we went terribly wrong. We got this terribly wrong. That's what we're trying to prevent.
Okay, thank you so much. Tyra, so we've kind of set the scene. We kind of know why this is needed now, having it been last done in 1906, 04, which is well beyond when any of us were born. And it needing to remedy something like child abuse. And child abuse is seen as not just physical abuse, but verbal abuse, emotional abuse. And these are things that affect Barbadian society, Barbadian children, parents, teachers, all these stakeholders that we would imagine are part of a society. So, having said that, the bill is meant to protect the rights of the child, correct? And we know that, just as the minister would have said, we are a signatory to the UN Rights of a Child, right? And we would think that not only is it important to protect the rights of the child, but is there another party that the bill should protect?
Well, thank you, Mr. for asking that question. It has been quite controversial, very much in the sense that we speak about parental rights. Because very much as we said, in terms of remedying mischief or misconduct or a violation, the question is who violates the child? And that is something that we need to take a deeper reflection upon. So the question that we've seen, that the state has certain types of authority. And of course, the family unit has its own authority as well. And the state have what we call that element of the harm principle. So the state cannot infringe on the rights of civilians or citizens unless if they're going to harm someone else. And so that's the only time the state has the right to intervene if you're going to hurt or harm someone. So the state does not have the authority to interfere with family life in the family structure in the home unless someone is being harmed. So in that case, we're looking at the Child Care Protection Bill. So that in itself, the state has the right to step in because the child is being harmed. But however, when you look at that bill, if there are two entities and they're negotiating, the state and the family, you're seeing in this bill, the state has more authority. And that should not be. And so the elements of negotiation changes because then it places the parents at a disadvantage. If we look at the previous bill, which the minister highlighted, and he said that, we've done very good because compared to what we have now, compared to what we had previously, we've done quite a lot, of course, because the last bill was like 17 pages and this is like 72 pages. Of course, you could imagine quite a lot has been included in there, and rightfully we should. We speak about cyber abuse, psychological abuse. These are areas that was not touched upon before. These, I think, even to this stage, people don't think about psychological abuse of children. And so, yes, you could see the diversion between what was happening before to now. However, in the past bill, you were seeing there was a provision for parental rights, but it's not in this one. The provision for the past bill speaks about parental rights, and it also sanctioned in terms of parents being permitted for punishment. But it doesn't clearly define of what punishment is, because sometimes when we think about punishment, we think about flogging children and whatever that it is, but it wasn't clearly defined. But in this bill, it doesn't speak about that. It doesn't speak about the family unit. It doesn't speak about providing that right for parents, and that's very, very strange that this happened. So when we think about the authority of the state and the authority of the parent, it becomes very problematic. Why? Because parental rights are universal rights, and the state ought to respect parental rights. And what it also does in this bill is that now the state provides more conditions as to what it is to be abused. So as opposed to before, you can say, okay, well, physical abuse, yes, we can step in. If you do not want to do certain things, we can step in. But now there are so much more provisions that parents have to be very mindful of. And I believe that I have said that quite a lot, that it is the onus of parents. If you get a copy of the bill, you can look at from page 10, you can look at the entire bill, but from page 10 to 17 to even 20, it shows the provisions or the conditions that the state has to intervene. And that's when it becomes worrisome, because it also states that if you do not, or you infringe on those conditions, or you participate in those conditions, we can hold you liable. We have every authority to take your children from you. We have every authority to speak on behalf of the child, because what it says again, which is very interesting, it speaks about the interest of the child. And if we can go through, I hope I'm not going too quickly.
I think we have, yes, you go, tell us which
And
page.
it's very important. The minister made a very interesting remark that we skimmed through the bill. And as an academic, we don't skim through documents or research.
Nor as a lawyer.
We don't. We don't do those things because there are reasons why you should not. Because if you do that, it's very unethical to do that.
Yes.
And so for us, it's very important that we go through exactly what is in there.
Yes.
And it's not in any way our words or what we're saying. We're just saying to the government, let's be mindful of the rights of parents. Let's be mindful of the conditions that you've placed in that bill that may infringe on the rights of parents. And the mere fact that the minister is saying that parents' rights are in there, parents' rights are not actually in there. It just shows you the conditions as to what the state can do, the authority of the state, as opposed to the parent. And so the argument is that the parent should have equal or even more rights than the state, and not vice versa. And the position that we have taken also, as I said before, are very old school, so I will go through the notes.
Yes. We have need for both old school and new school.
And if you look on page 10 where it speaks about interpretation, which is very important,
Yes.
because interpretation deals with the legal aspect of it,
Mhm.
how the language, the legal language of it. And so it states that in this act, it defines what abuse is.
Yes.
It includes child labor, which is very interesting because I
Mhm.
read an article today coming from the US where a state in Ohio, I believe, where they're thinking about having children to work in public spaces, in bars, as young as 14-year-olds. And so these are kinds of questions that we need to ask ourselves as Barbadians, as Caribbean people. These are the kind of environments that we'd like. And these were laws, and I'm sure the US have laws on labor rights and child protection against child labor. But now we're seeing legislators are looking to change that.
Yeah.
And so that's very important. So as we go below, it gives you a very clear distinction as to what that abuse entails. And also we can all agree in terms of physical abuse, sexual abuse, verbal abuse. And of course we know sometimes we as parents, we can get a little loud. But abuse in
Yeah.
itself, we know what abuse is. Abuse in foul language, demeaning and
Yes,
bullying
bullying.
children. So we can all agree to that. But what is very interesting is when we go down a little further, we'll see what authority is. The authority and those terms and interpretation is very important because this is the language that we use throughout the bill. So when you see the word, you would go back and say, oh, that's what it means here. And so as you go a little further, it also tells you that authority means the Child Protection Authority. And it takes you to Section 8 and it explains what that is. It also tells you what is best interest, means the best interest of the child. What does that mean? And that is usually the question. Who determines what is the best interest of the
a
child?
child.
Is it the child who's probably 14 or 6 or 8? I have a 6-year-old who sometimes tells me he's Spider-Man. And sometimes he tells me that he's Sonic. And so at this age, we can understand the level of understanding and cognitive ability as well. And so that's very important that we understand those dynamics. Who determines the best interest of the child?
Yeah.
And in this case, it is either the child, the state, or the authorities, not the parent.
Very interesting. A very interesting circumstance for a 2023 bill in a space where we know children rights and rights of parents are just as important.
Correct. And it also seems that there may be instances, and of course we have to be practical because it's a law, and law deals and governs conduct. You will find where there are circumstances where the parental rights may collide with the state. Now, when that happens, what do? You're a parent,
Yeah.
and the state has authority. I will give you a very good example. Was it last year, there was this discussion that we may mandate vaccination for our children, COVID vaccination for children. There was quite a number of discussions on that. There was quite a number of discussions that children may, if they do not get vaccines, they will not go to school. Now, how does a parent deal with that? If a parent decides that I am not going to do that, then does the state have the right to say that, well, if you don't do that, it's in the best interest of the child, chances are you are violating the child's rights. And so all of these things, it's included in here. On page 12, it tells you that consent to medical treatment not involving surgery of the child on the advice of the medical practitioner. But also it goes very closely, and I wanted the minister to go as well. So it starts from page 11 to 12, because I remember the minister said it says nothing about surgery. But under care responsibility, which is on page 11, it says care responsibility means the authority of the authority. So the authority of the authority. The language tells you again. So the authority, basically they could have just said the authority of the state and make it very short. But what it also does, it says under care responsibility, it says consent to the medical treatment not involving surgery for the child on the advice of a medical practitioner. There's nothing about parents here. Part B, it says consent to medical treatment involving surgery that a medical practitioner certifies in writing needs to be carried as a matter of urgency and in the best interest of the child. And so in all of those circumstances, you can almost imagine that if you have, for example, which is very good when we use those thought experiments, you think about a 13-year-old who thinks it is the best interest of them to do whatever types of, I don't know, liposuction, I don't know. We're just
Tattoos,
thinking whatever
all
that
sorts
it
of
is. And the child determines that that is in their best interest, but the parent is not there. And if the parents say, well, no, I don't think that's the best thing for you. In other cases, we've seen, even when you look at in terms of various ethical questions, in certain societies, children are not permitted to be euthanized. So we have children under medical care that decide, you know, I'm too sick, I think I'm terminally sick, I believe I should die. And the parent is saying no. And in such instances, the state comes in and say, well, let's look at who's the best interest, what interest should we take? Certain societies does not allow the child to make that decision, but the parent.
Yeah.
And so in that bill, you're seeing those circumstances, and it would be prudent that the minister and those responsible think a little bit more critically of the various situations that can happen, because you can't deal with a law case by case. It is a law. And so what you want to do is to ensure that it covers every condition and every circumstance.
Yeah.
And that is what is very important in it. So if you go through the bill, you will see quite a lot of concerning areas. Another thing that I observed as well, another area that I observed, would be on page 13 that deals with the neglect of the child. Now, the neglect of the child, again, it speaks about the failure of a parent of the child to provide the child with adequate care and guidance. It goes further, any act or omission by the parent in respect to the child that is inappropriate for the child or likely to be harmful to the child. So it speaks again, and particularly for this one stood out for me, because what it does, it criminalizes the parent immediately, almost immediately. What do you mean by neglect? But also, we know that neglect does not only happen within homes.
Yeah.
It can happen in childcare centers. It can happen in homes, in foster homes.
Yes, that's it.
But the law, the bill does not make any provisions for that kind of neglect on the part of the state. So what it actually does is that it exonerates itself from any responsibility.
Wow.
So it protects itself.
So the
While at
state,
the same, yeah,
the state is protecting itself
Correct.
in its bill.
in this bill.
Okay.
And so that is the question. And
That's a
we've
major
seen what has
question.
happened, and I would ask again, the issue of the last year's survey. When certain authorities violate the rights of children, how do parents hold them accountable?
Yes.
When there are various types of violation, how do parents, because at the end of the day, the state does not own children.
No.
Not even parents
Not the
own children.
responsibility, Nobody.
But at the same time, the parents have that sacred right and that legal right over their children. And the only reason the state has the right to intervene is, as I said before, if parents are directly
Directly.
violating children. And so when we look at it in terms of the best interest of the child and the considerations, all of these things, it raises those fundamental questions about the interpretation of the law. And I think Tyra could tell you very
Yes.
clearly, if there's any ambiguity in the law, it is
What
the
that allows for.
responsibility of the person who created the law to
Make it
revise
clear.
it.
Yeah.
Yes.
To make it clear.
Definitely. So where there's ambiguity in the law, it leaves it open for interpretation. And that can be a dangerous thing. We see it often in criminal law, where there are loopholes in the law because there was ambiguity. And so when when I say we lawyers, when we stand up and we argue and we start to apply different rules of interpretation, whether it be the golden rule, which is just the ordinary definition of the word, the mischief rule, the purposive approach, I can list them. And we go on and we make an argument. Depending on how strong our argument is, the judge or the jury will kind of be forced to accept it, right? So we have a situation where the general or the provision is so general that depending on how you argue it, so depending on whose interest you're representing, you can sway the law in either direction. And this can be a dangerous thing. So ambiguity can either be your best friend or it could be your worst enemy, depending on which side you're representing, whose interests you're arguing for. So what we're saying is we do not want a situation where really and truly the act was established to protect children. And also, well, Humphrey's saying the parents, but we're not seeing it. But instead it's used as a divider in the family homes because now you're putting the children against the parent. And then even further, it's used as a tool or an instrument of power for the state to establish or exert its authority over the family home. And that those two things should be kept separate. The state and the family should be kept separate. And the state should only be given the authority to intervene where it is absolutely prudent. And I remember on Sunday I used the term a draconian measure. Now in law, a draconian measure is something that is so strong, so stringent that really it should only be used in the most extreme of circumstances. Now there's a section, section 22.3, and you can find it on page 30.
Page 30
Yeah.
of in the actual bill.
Yeah.
I think we will pull that up for you, Tyra.
Mhm. So when you look at the page 3030 and you look at section 22.3, it does say the removal of a child from his parents shall only occur where it is necessary to protect the child from the risk of serious harm or danger. Now, the layperson looking at that might say, well, it mentions, only removing the child where it is necessary, so they have addressed it. But if you look at it with a legal eye, you'll find the loopholes. And the loopholes are, I'll tell you now, you see that word necessary? Necessary is a subjective term, a subjective phrase, meaning what's necessary to me may not be necessary to you, and vice versa. So who determines what is
What's
necessary? And does it vary depending on who the decision maker is? Because the director is not going to be the same person from now until thy kingdom come, right? And also the judge or the magistrate in this case, because they've made the offenses triable summarily, but as a different topic I'll go into later.
Yeah, we will discuss that.
Depending on who the magistrate is then, that's what is necessary. So what would be necessary to magistrate A may not be necessary to magistrate B. That's the point I'm making. So it is a subjective term. And when you have subjective terms, you often should balance it with objective conditions, objective requirements. So there should be a further subsection
Of
right
that.
here,
Mhm.
which clearly states, well, these are the factors you should look at when determining or when making the determination that it was necessary to intervene. And this then provides a guideline, you could say, for the decision maker to look at, to say, okay, well, this is what I need to consult before I make the decision that it was necessary to remove the child. On the flip side, what it also does is it provides equality, because it then gives parents and children the tools necessary or needed for them to then argue their case. Because they can say, look, here at section such and such, it said that you were supposed to examine this, but you failed to examine it. Or you can say, you examined this and you weren't supposed to examine this. And then it gives the parent a right of appeal. So, and that's very important, because when a decision maker makes a decision ultra vires, which is a legal term, which basically means they made the decision without the authority of making it, either because they considered irrelevant circumstances or they failed to consider relevant circumstances. You then give the person who was affected by the decision the authority to say, I don't like the decision, this is what is legally wrong with it, and therefore I am appealing the decision. I don't see anything in here about an appeal. I don't see anything in here about conditions which would even give you the thought that you have a right to appeal. So that is something that is wrong with it.
Yeah, it seems to be another situation of cart before.
Exactly. And then the other word that I want you all to look at is that word risk.
Mm-hmm.
Because that word risk is a funny, funny thing. If you're saying the removal of a child from his parents shall only occur where it is necessary to protect the child from the risk of serious harm or danger, what was the risk? What and who determines?
Me might not be a risk to you.
Correct. And who determines what's the risk? So you're saying not only will we remove a child, or not only do we have the authority to remove a child where there is actual abuse, but where there's a risk of abuse. And who determines that there was a risk? Is it the malicious next door neighbor? Is it the child that is upset because you took away their cell phone?
Mm-hmm. Yes. A very topical thing right now, actually. And so even looking at the language, we know that there are definite problems. Now, if we look at the legal system, which Minister Humphrey would have highlighted in terms of how to handle cases that need to be put before the court, tell us a little about the system he's highlighted and what challenges you see, Tyra, as an attorney at law, and where does the buck stop?
So he actually hasn't highlighted anything. The legislation makes the offenses triable summarily. So it's the legislation which says, and this is for the layperson out there, that these cases, the cases or the reports that fall under here, which then turn into criminal matters, will be dealt with at the magisterial level. So they will be dealt with the magistrates and the magistrate courts. Minister Humphrey didn't actually address my concerns on this. He took a personal attack. He did not defend my position.
What does it say? It's supposed to go to the magistrate court, but there are obvious issues in the magistrate court. He did say that there are over 600 cases reported. We're not even talking about the non-reported cases.
So what I learned from doing my homework and from doing my research, I just attended a criminal law symposium not too long ago. It was held at the Hilton Resort, very beautiful. And there it was reported that there is a backlog of 16,000 cases right now.
In Barbados?
In Barbados, at the magistrate courts, and this is only criminal law cases. This does not encompass the civil side of things. This does not encompass the ongoing active new cases that come in every single day. It's a backlog. So where you have a backlog of 16,000 cases, and clearly the magistrates are stakeholders of this legislation because they're the ones you've put in charge to handle these charges, right? You're going to put more work on them, really? And we have not even addressed the system that they're working or they're operating under, because there's obviously a flaw in the system for there to even be 16,000 cases backlogged in the first place. So how are you giving magistrates more work and further burdening the magistrate court system? And you have not even began to address the issues that the magistrates are facing on a day-to-day basis. So some of the issues, for example, are the magistrates, they're so forced to write longhand notes. There's no clerk nor typewriter nor any technical support. There's no technical support for them. A lot of them operate out of facilities which were built probably before it was born.
Maybe in the same 1904.
Right? They literally have to sit down in their suits, be hot and sweaty. A lot of them, like in the high courts, there's a recording system. So you speak into a mic, and then you get a transcript at the end of your trial based off of what the mic would have recorded. That does not happen at the magistrate court level. So the judge actually, or the magistrate, has to remember everything that was said or done. And they write, and it's based off of their notes that then they will be able to make a decision. So that in itself is problematic, right? Also, the pool of magistrates, very small pool. And as we lawyers know, all cases start at magistrate court level. Some of them get sent up to the assizes if they're indictable, but all of them begin at the magistrate court level. So it's the starting point. So if that's the starting point for all the cases, it should be something that's very important, right? You should want to deal with them. So a lot of the complaints coming out from the magistrates are things like what I just mentioned, and also they don't have security of tenure. they are not paid as much as high court judges. And then the name in itself, we still refer to them as magistrates instead of like district judges or lower court judges, anything of the sort. So there's a clear separation between the two. And they're not treated as favorably as high court judges. So we have problems in the system itself. And you're adding more problems by adding more pressure, giving them more work, but then you're not looking at them, you know, and raising the conditions that they're operating out of. And I think that's unfair. It's wrong. And it just shows that enough research was not done before this bill was put in place.
Yeah, it definitely does show either enough time and effort seems to be missing. And as Felicia would have highlighted, the ambiguity in the language really leaves a lot for discussion, which shouldn't be in something as important as this, given who it's protecting. Children are one of the most vulnerable citizens in our country, and therefore any bill that seeks to protect them should go through a proper process where the bill that comes before the House of Assembly is one that, one, makes sense, two, one that at the heart of it makes whether it be the court system or the rights of parents and the state be seen properly and not left into interpretation. And so although those are the major issues, is there now an opportunity for the minister or the ministry of People Empowerment and Elder Affairs to revamp what they have in the bill? Because I know you've gone through it with a fine-tooth comb, as Barbadians say. And where do you see what needs to happen now, given where we are right now with the bill?
I think at this stage, I believe that we just have to educate the populace. I don't believe that the government is going to go back and change anything in this bill because of their statements that were made in Parliament on Tuesday that persons that speak on the bill are making it political as opposed to seeing where collaboration could be done, where we are citizens as well, whether we may have political interests or not. We are still citizens and we all want the best for the country and for our children. And so it is always good to collaborate as opposed to provide opposition. And so it reminds me of a time that the same minister had some challenges with the elderly bill, where I believe a group of young, progressive attorneys did it on their own to develop and draft a bill for elderly care. And the way the minister responded publicly was really to humiliate the young men until I think later on they were able to reduce that and come together to do that. So it's very important that even when people speak from different perspectives and ideologies and positions, that we still take the opportunities to sit down and listen and critically think about what would be the good judgment that I can make in this situation. Because the minister is not making this law because it is his own law and it governs himself in his own world. It is something for the entire nation. And I believe that he should think of the collective approach. And yes, he did highlight the various institutions and the various individuals and the child rights advocate and everybody else. But there's nothing wrong with any other person taking another look at the same bill and saying, wait a minute, I think you may have missed something. As a brother, as a sister, let us go back and make sure that we get it right for the interests of everyone. But it doesn't seem that it will be welcomed because, again, if you are political, that means you come in from a very aggressive nature or very opposing and antagonistic way, but that is not the point. The point is, if we are brothers and sisters and we see something is wrong, that in the future may bring certain dire consequences for parents in particular and even children, Because if parents can counsel their children on certain fundamental issues, whether it's legal issues, spiritual issues, medical issues, social issues, even political issues, then who are they counseling? Children spend the majority of their time with their parents. And even when they're adults, they still spend time with their parents. To this day, at my age, my mom calls me every day. And sometimes we too call our parents like, listen, we have a little problem. What do you think about that? Because we still seek counsel from our parents. And what the state need to realize, regardless of who their representative is that the parents are the voices of children. They are the best interpreters of the law. So children may have the interest, as I said before. Everybody has interest. From the time you're born, you have an interest. The time that you have awareness, you have an interest. Whether it's playing with stones or tactiles or frogs or whatever it is. And as you develop as an adult, you will have interests as well. But the reason why parents are around is to provide that guidance. We have a society, and I went to a symposium today that deals with crime prevention at the university. And some of what was being said, the research is showing that one of the factors of crime is from the family, from the school structure. And so we see what had happened. And even the Minister for Home Affairs made the statement that they're spending $13 million on crime prevention. But at the same time, what drew my thought to that was we're spending all that money, but at the same time, it's the parents at our home that are making sure that we nurture our children in a way that you don't have to spend that $30 million
Yes, definitely.
to protect the society. Yet at the same time, you're creating provisions that will criminalize parents very easily, very easily. And if I may just go back very quickly, I just
Yes.
want parents, if they have an opportunity, to go also to page 18.
So I'll just say now the bill can be found on the website of the Barbados Parliament, and you can easily go to the section that highlights bills, and you will see, I think it's the 10th bill down on the site.
You can do a quick Google search. as
Download
well.
it and go through it for yourself, talk about it with your friends, and I encourage Barbadians to do that because this is our country and we need to pay attention to what's happening and not turn a blind eye to anyone who is in authority.
So from page 18, it speaks about child in need of care and protection, and it outlines all the conditions where a child would need care and protection from parents, from societal members. And what stood out for me primarily would be, again, G and H, where it says a child in need of care and protection was a child that suffers from mental, emotional, physical, developmental conditions that requires treatment to care, prevention, and of course the effects of that condition. So the treatment to cure is very important.
Yes.
What do we mean
By
by
that.
treatment? Because when we think about emotional, I mean, children go through different stages, as I said. You have some children, if they believe that they can run as fast as Sonic and there's a drug, they can take it. Of course they would, probably. If they can drink something or
Yeah.
change the features. And so these are real issues that we have in other societies. And so it speaks about that. It speaks also on the fact that if a parent does not or refuse to obtain the treatment or is not available to provide consent, the state has the permission and the authority to step in. And so what is very important is how it also defines a child. A child is anyone under the age of 18. And so if you have children that believe that is in the best interest to, whatever that it is, psychological or what it is, if they feel, and I don't want to really go to that direction, but these are conversations that they have every day. They have children that feel that they're male or female and want to change the sex identity. Are we a society now that believe that a 6-year-old should be given that right because psychologically that's how he feels? We need to pose those questions, not because we want to create judgment,
Yeah.
but
Yeah,
we
I
need
would
to
agree.
ask those questions so that parents can be informed, involved, and so that they can make sound decisions. And that's what's important. So we're providing that information and we alerting parents to take note of what is happening and the gradual progression of your societies. See what is happening around the world. Because Barbados does not work in isolation. No country is an island. And so it's very important that we see the different facets of what is happening socially, politically, in certain societies, and how having certain types of legislation may impact upon parental rights. So having parental rights does not diminish the rights of children. What it does is it enforces the rights of children. It empowers
The rights of
the
children.
child and protects the child in some cases, even against the state.
Yeah.
And that's why it's very important.
Yeah, definitely. And I think it's something we can't afford to sidestep, whether we look at it from an advocacy standpoint or from a legal standpoint. The rights of parents help to guide a society in large measure, and parents are constituents who cannot be pushed aside or anything like that. How did the bill, in terms of stakeholder engagement, get to the House of Assembly? Does anybody know if there was any stakeholder engagement?
I don't know. I didn't hear about any. Humphrey did say that he consulted 3 different lawyers, and all 3 had a different opinion, but I would love to hear what their opinions were. I would really love to hear. I think that's a general theme that has been happening with this particular administration. They oftentimes just give you things as a matter of fact, and then they say, yeah, we consulted persons about it, but when you speak to members of the public, everyone, they're like, majority of the people don't know what consultations you're talking about. So I don't know, something's not adding up.
Definitely. I don't know if you in your UE space or in your advocacy space, Felicia, heard any or were involved in any engagement that this bill would have seen as it processed its way to the House of Assembly.
Well, we can ask those questions. We can see who is involved, because even if when you look at your own spaces, you don't know who was the representative of your space, so we cannot indefinitely say, yes, we know who. But I believe the only space which is paramount is the public space.
Right.
Was there any town hall meetings? Was parents consulted? Was the national PTA members part of the consultation? And these are very important, because what we're trying to also say is that the stakeholders have a more profound influence on bills. I would tend to defer. The bill will affect the common man on the ZR.
Yeah, definitely.
The parent that is just trying to do the trade and just live for life. These are the people that the bill will affect mostly.
Yeah, because I know we have instances where parents might have a shop
Correct?
and their teenager might help them in the shop, be an assistant on a Saturday or a weekend, or be coming against the child. It affects that kind of dynamic. A parent might be a vendor. You know, those types of things are the everyday things that we Barbadians do daily. And how do you operate in your home as a parent with your child who, as you said, might want to identify as something that they are not physically? How do we have those types of conversations with our children and guide them through those processes? Because we know each of our child personally. It's not as though the state does.
No.
And that's the point of being a parent. As you're a mother, I'm sure, as you said, your son wants to be Sonic, And they go through that phase where superheroes are appealing. They go through the phase of helping mommy in the shop or selling something at home because they need the extra money. Are child rights, is this child right protection bill touching on any of those subjects? Those are things that we need to be aware of, I think, going forward. And how does it impact me as a parent?
Well,
Yeah.
that's a question that you have to look at it from the lens of the average Barbadian.
Yeah.
And that's what it's because these are the people that the law, what I think we say in legal terms, the man on the omnibus, the man on the bus, the average man on the bus. But I just want to add, I just had a thought that the administration will tell you, well, no, that's not what we mean in terms of surgery. We mean that if the child, something may have happened and the child needs intervention, that if the parent refuses, then we have. Because there have had cases where, for instance, there's certain religious groups that do not allow blood transfusions.
Yes.
Now, the state would say, well, if the child needs a blood transfusion and the mother or the parent says no because of religious beliefs, then we as a
How do you
state have the
navigate
right
that?
to deal with it.
Mm-hmm.
Then what do you do as a parent? Do you say, well, I
I
diminish
see this
all
as
my rights?
necessary.
Right, exactly.
But does the state has the right to intervene? Because if that is your religious conviction, does the state have the right to intervene?
Yeah.
Now, these are the types of questions that needs to be asked because it also focuses on ethical questions
Right.
Yeah.
where the state will say, well, we need to save the child's life
life.
first and foremost,
Mm-hmm.
but then you have the parents' rights. So in such bills, you're seeing the conflict or the collide where the parent and the state
Yeah.
trying to save the life of a child. And it could work either way, as I said before. But we have to look at the conditions.
Yeah.
But at the same time, if the state decides, they barely have any much resources, to decide that we're going to deal with things on a case-by-case basis, could you imagine the amount of money that will be spent on those issues? So we have to make these things clear. If we're going to talk about surgery, what are the provisions?
Yeah.
If we're going to talk about parental rights, what are the provisions?
Make it clear.
Make it clear, like the man on the Zeta and the
Exactly.
mother
In
from the
shop.
fish market
Exactly.
will understand, well,
Yes.
these are my rights
Make
as a
it clear.
parent, and no state, no authority has that right to intervene. Even
Yeah.
if my child say, well, yes, I want to do this and I want to do that, I'm the parent, and I will make those decisions for you because the state does not have that authority.
Yeah, definitely. Thank you so
There's-
much.
There's another important point I think the public need to turn their attention to. If you look at section 13, which is found on page
Page-
27,
Okay.
it speaks about staff, right? Staff meaning those persons who will be employed
Oh, yes.
to care for the children at these centers, right? It says, subject to subsections 2 and 3, the board may appoint and employ such officers, agents, and servants as it considers necessary for the proper carrying into effect of the provisions of this act, at such remuneration and on such terms and conditions as the minister approves in writing. But nowhere in the legislation does it offer any form of pre-qualifications for persons who are interested in becoming staff or who are interested in becoming foster parents. And I think that is an inherent defect and it needs to be addressed because there's nothing in there that suggests, okay, before persons can become staff or foster parents, they need to be subjected to a psychological evaluation. They need to be subjected to a background test. They need to be employed because
certificate of character.
exactly, because there are instances where we've seen it in other countries where children are taken from a bad situation and put in an even worse situation. There have been many testimonials from children who actually came through that foster home or that group.
System.
Yeah, I think they call it group homes in those countries. They come through that system and they say, listen, when from the day I was removed from the home, unspeakable things happened to me. I was raped, I was beaten, I was locked up in a room. I was treated like a dog. They didn't care about me. They literally only wanted me because they knew a check would come from estate every single month. And so you want to avoid a situation like that where children are then subjected, true victims of abuse are then subjected to further abuse and further neglect. You don't want that. So in order to prevent that, it needs to make it clear in the legislation who qualifies to be a member of staff, who qualifies to be a foster parent. And I think those conditions need to be adhered to very, very carefully. Because that's a touchy situation, like you said. You know your children best. Your children know you. But then you're removing children from homes where they know their parents.
Where they don't have or know
and you put them with a stranger.
Responsible for them.
Exactly. You put them with a stranger. Even worse, you put them in a center full of strangers. So you don't want a situation like that. And then training. Do these foster parents or these staff members, do they have to go through training into how to deal with a child that has been traumatized or a child that has been abused or neglected? Because that's a special type of child. You have to know how to deal with a situation like that. It's not just an ordinary child. These are, I don't want to use the word damaged, but they're damaged children. Mm-hmm. So how do you deal with that? You have to be trained. You can't just employ every and anybody to deal with that, because then it creates a potentially worse situation, and that's something we're trying to avoid.
Okay, so that is actually a really major point in moving forward. So we're almost out of time, so I'm going to ask Felicia if she has any closing remarks, given where we are, given all we've discussed today, and how we could move forward on this child protection bill as you would have it.
I just want us to be reminded that a parent is a parent, regardless of their social, political, ethical positions, and also sexual positions as well. Because we want to understand that there are parents with different sexual orientations, but they're still parents. And so they still have rights. And so we have to respect those rights. We have to uphold those rights as well and promote the rights of parents. And even to the fact that in this bill, and as much as we want to be very concerned about certain areas, we have to give them an applause for wanting to bring it, but we spoke about that already.
Them on that.
And also including that there's certain aspect of it that is necessary in terms of the different types of abuses. And also on page 28, it speaks about the role of the minister. And I want him to go back and read that if he hasn't done so. It's very important because in there it says that the minister shall promote a partnership approach with families. And so, Mr. Minister, please reach out to parental rights. Ensure that parental rights are covered. And it's not too ambiguous that it criminalizes the parent. Because parents are really the ones, as I said before, that's going to protect our children, going to protect the children of the societies, provide them with the guidance, the foundations that they need. And so work with parents, ensure their rights are not diminished in this bill.
I think that's a really important, critical point, highlighting the exact bill and his responsibility as minister to engage and promote and have conversations with parents as a major stakeholder with respect to this bill. And as we come up to time, Tyra, I don't know if you would like to share your own advice or points that you think need to be heard in the wider quarters of Barbados.
Yeah, so I'm speaking directly to the public now. I implore you to go pull up the bill yourself. You could go through the parliamentary page, or you could just do a simple Google search. Just type in Child Protection Bill Barbados, and it will come up. Read it yourselves. Come to your own conclusions. Don't just take our word for it, because this is not a political thing. This is not about politics. This is really both of us, all of us here, we care about children. And we don't want the message to be lost because of who is giving you the message. So please take off your political blinders and just really look at it for what it is. Ask yourself, does it make sense? Is there merit in what they're saying? And if you find that there is merit, I am encouraging you to please stand up for your rights. Stand up for the rights of your children. Protect your children at all costs. All costs. This is not a political stunt. This is not for political gain. This is a concerned citizen, concerned parents who are talking to you, who are begging you, please do not make a mistake and have this legislation be enacted. And then further down the road, you find yourself in a position you do not want to be in. And we find ourselves in a Barbados we do not want to live in. Please, I am begging you, for the sake of the children, please go and look at the legislation. I am begging you.
Okay, so we have Tyra, who gave us a really good and sound footing regarding the legal perspective, and we had Felicia, who very willingly shared quite a lot on the rights of parents and not criminalizing the rights of parents in Barbados, as the Ministry of People Empowerment and Elder Affairs moves forward, and also the need to have more stakeholder engagement in terms of any other legislation and this legislation moving forward. We are encouraging Barbadians to look for themselves, to use their own lens, to use their own experience as parents and godparents, everybody who's involved in our society, to look through the bill themselves, examine it for yourself, take the time, because this is where our country is moving forward. And yes, the Democratic Labour Party has used this space to bring something that's really important to you through this broadcast, but at the end of the day, it will impact all of our lives. It will impact how we are able to parent, and it will impact the way child rights maneuvers in Barbados. So thanks so much, everyone, for joining us in our front house today as we discuss the Child Protection Bill, and we look forward to seeing you next time at the front house.
What's going on with these children in this country? Like something gone wrong with the brain. They're heading down a road of mass destruction, and later on they will feel the pain. These school boys on their backs have all kinds of weapons, like they're heading to a war